Hello, everyone, and welcome back to yet another session on polity and constitution. I hope I am audible as well as visible. Great, audible and visible. Okay, so let's begin our discussion. So, in the previous class, that is, we had discussed about the courts, the judiciary, starting with the Supreme Court, of course. Though in the previous class, we had already discussed about the collegium system. So in the previous class, we took up for discussion the other aspects pertaining to the Supreme Court judges, including their removal, ad hoc judges, permanent retired judges, court of records, seat of Supreme Court, and then the jurisdiction of the Supreme Court, various types of jurisdictions, and also the high courts and the lower courts, the subordinate courts. Today we'll begin a discussion on NALSA and the issues concerning judiciary, right? So let's begin now. Vijay Raghavan, in Panchayat, they are nominated members by state legislature by law, like Panchayat. Is there any? No, Vijay Raghavan, not in the mayor in council, but the standing committee has members who are nominated only, right? To make appointment of judges in Supreme Court collegium at least same majority, right? Same majority, 4:1. So it's exactly the same. Swayan, we'll discuss NALSA today, so have patience. Muskan, is it the first class that you are attending? Recordings are provided for these classes. Don't worry. Okay. Guys who are attending their very first class, of course, you'll have to relax and just calm down on things because half the classes are over, right? So accordingly, whatever you can understand, good for you, or else join the next polity batch, or you can firstly go through the previous classes and then only, right, look into these classes. Okay. And for issues of getting recordings of lectures, the experts will address it, so don't panic, don't worry. Every lecture that we take is recorded for you to view it any number of times. Okay, that's not a concern. Okay, one by one, just relax. I'll respond to your queries. Okay. uh, Puja, starting with that. So yesterday you told a lawyer of high court qualification is 10 years high court judge. Puja, come on. What is this? High court judge's qualification is to be a lawyer. Please look at the slides. Ankit, they are appointed by the governor but elected by the house. Uh, Ananya, so what is the concern here? What's the concern? I cannot respond to mails immediately. Just have patience, right? Rishu, sir, could we initiate case against judges after getting proven guilty by the committee after the resignation? If a case violates some law in the country, like the Prevention of Corruption Act, etc., yes, of course. Or else, sorry, that can't be done. Shubham, Article 243N. Article 243N simply says that a lot of panchayats did exist before the before the 73rd Amendment Act. Now, in all these states where the panchayats existed, the panchayats were supposed to continue to exist, right? But if there was any provision in the panchayats which violated a law or which violated the 73rd Amendment Act provisions, those provisions would continue only for 1 year. Within 1 year, the state had to modify their original laws to bring them in line with the new panchayat provisions. That's it. Shalja, there is no such thing as maximum or minimum age, right? So it's all the prime minister who decides all these things. Uh, Ankit, that may be possible. Yes. Pranav, district collector is an officer. District DC and DM are IAS officers. District magistrate, district magistrate is an IAS officer who is in charge of administration of the entire district. And judicial magistrates are judges in the lower court. Okay, all the lower court judges are collectively called district judge. It's not one person or one post. Just like if I say IAS officer, it means so many officers. Cabinet secretary is also an IAS officer. DM is also an IAS officer. Difference. Because Ankita, the ordinance making power is the power exercised by the Council of Ministers in reality. Okay. Prem Kumar, let's at least proceed first. Why asking this question on activism? We'll come to that. Don't worry. Nuti Kadisa, you said 124 creation of NJAC. Then what about sedition? What sedition? Nuti Kudi, I don't understand your question only. What has NJAC got to do with sedition? Anyway. Rishu, I don't think there's any discrimination in this regard. Pooja, he is not eligible to be appointed as Supreme Court judge. They are just asked to attend the Supreme Court, not become a judge in the Supreme Court. Yes, Kavanayan, that's possible. Now you can write those articles in your notebooks, right? PU, magistrate cum civil judge, is the judge at the lowest level of judiciary. At the lowest level of judiciary, that person is called the magistrate cum civil judge. Lakshmi, those are straightforward questions. That may not be possible. Nothing to discuss there. These are extremely straightforward questions. What to discuss there? Jennifer, what's your query? Anurag, that could be for taxation matters. It's quite possible. Any other query that we have? Let's see. Ask from topic which have been taught so far. Asking from something in the future we'll be discussing makes no sense. Admiralty's laws say UN clause issues. If there is any kind of issue between two states, or forget if there is any issue in your district with respect to any water body, right? Those issues will be resolved in the high courts only. Revise, Shweta, just revise. Abdullah, we are doing it along with the class only. If you have been attending the class, that is. If not, then it's beyond my control. Issue high courts. Jennifer, because it is mentioned in the constitution for Supreme Court, and for High Court, it's a generic practice. Simple. Pooja, warrant under hand and seal refers to the appointment personally made by the state, meaning the president. He signs on his own seal is used. This shows status and respect. Okay. A issue of whichever state has been given, whichever high court has been given the jurisdiction, right? Palak, water disputes are resolved by tribunals separately, not by High Court or Supreme Court until and unless clearly mentioned. Yes, Divya, it's for every judge, including Chief Justice of India, right? Rishu, High Court of the state in which they have a jurisdiction, both of them can look into the matter and see as to which High Court they want to approach. Okay, they can both file a separate High Court, a separate case in the different High Courts, and then it can be decided accordingly. Manam, if at any given point of time your case is not fit for appeal in Supreme Court according to High Court, or the case is not really important, then you can request the Supreme Court to take up your case, and if the Supreme Court thinks fit, it can take up your case. Okay, that's it. Let's begin our discussion for the day now. No 5 questions for today. We'll directly start with our discussion on NALSA. Oh, it is my wish actually, Roshan and Tarun. Completely dependent on me, right? Okay, happy? Satisfied with the response? Let's move on now. Okay. No, actually, for others who understand the value of respect, the point is that I did make those questions, but because of some issue in updating the PPT, they got misplaced by me. That is why no questions for today. Okay. Now let's begin our discussion without wasting much time. Coming to NALSA. It is no problem. It's okay. Don't type no problem. Right? Okay. So we are done with our discussions. On Supreme Court, High Court, and lower courts. Now we look into the issues concerning judiciary. Before that, two important points. One is a very important factor of NALSA. This time a question was asked on NALSA. You'll be amazed that verbatim question, a very, very easy question was asked on NALSA. Basically, what happens is, you have to understand a very important point. And that point is that I think all of you would agree that justice has become slightly costly, right? It is costly, at least quality justice. And in our provisions of the Constitution, there is an article called Article 39A. That article talks about free legal aid to the poor people. Eventually, it is very important to have some alternative for the poor people. So, this Article 39 capital A, which was added in 1976, it talks about free legal aid to poor. In pursuance of this, that the article says that the state should provide for free legal aid with suitable legislation. So back in 1987, a law was made called Legal Services Authorities Act. And under this law, a body was formed. That body is called NALSA. NALSA. I mean, the body is National Legal Services Authority, NALSA, right? So this is NALSA. It was established in under this law in 1995. And what's the purpose? The purpose is to create a nationwide uniform network for providing, mind you, free and competent legal service. So free and quality legal service to the weaker sections of the society. Okay. So legal service is going to be provided, which is going to be free of cost, of course, and will be competent legal service, good quality legal service to the weaker sections. Now, who is this weaker section? What is the legal service? We'll discuss shortly. Don't worry. See, this NALSA is under the Supreme Court. So Supreme Court takes care of this aspect of NALSA, and the Chief Justice of India is the head of NALSA. He is called the patron in chief, the formal head. But because CJI is also busy in other activities, so the actual functioning, the real executive chairperson is the senior most Supreme Court judge, just junior to CJI. So the executive chairperson is the senior most Supreme Court judge. This person is actually in charge of overseeing the effectiveness of NALSA. Now, did you read one point here? Establishing a nationwide network. It is not that people have a problem only in filing case in Supreme Court. A poor person may have a problem in filing case in the lower court also, in the high court also. At the district court level, we have seen there are so many levels. a judicial magistrates court, additional JM first class, sessions court, this court, that court. Everywhere there could be a problem, because everywhere you need the knowledge to file a case, you need a lawyer, all these things. So there is a nationwide structure. And what is the structure? So at the head, we have NALSA at the top. Below NALSA, at every state level, we have SALSA, State Legal Service Authority. SALSA. We have in our country 37 SALSAs, 37 in number. This number not really important, just for information. Under every SALSA, we have a body called DALSA, District Legal Service Authority. District Legal Service Authority, DALSA. At the district level, we have 673 DALSAs. And at the block level also, right till the grassroots, at the block taluk level, we have not TALSA, but TLSC. That is Taluk Legal Service Committee, TLSC. So over 2,351 such TLSCs, right? Apart from it, we have a separate Supreme Court Legal Service Committee. We have separate High Court Legal Service Committees, right? So 39 High Court Legal Service Committees are there beyond this, right? So that is there with respect to the entire structure. Clear? So ideally, see, I'm not saying for every court there will be one SALSA, DALSA. That may not be possible, especially at the lower level. It may not be possible. But within a taluk level, you will be able to approach some TLSC to get some assistance in filing a case. Same goes for district. Same goes for your state also. Clear? Some states have more than one SLSA. Bigger states, UP, right? Maharashtra, Tamil Nadu, right? Karnataka, they have multiple SLSs. Beyond that, we also have UTs. So for UTs also, you have SLSA. Okay. So now, coming to the key programs, what exactly is the task of NALSA, SALSA, DALSA, TLSC, all these bodies? So the task is legal aid and assistance. Providing legal aid and assistance to eligible categories of people before courts, tribunals, etc. Legal assistance is provided to eligible categories of people, right? What is legal assistance? This is a legal service. When you file a case in the court, what all things are required? Payment of court fees, some kind of processing fees. You have to get the service of lawyers also, right? Then you have to obtain supply of copies of judgment, court order. You have to obtain a court order copy. For that also money is required, 30, 40, 50, 100, 200 rupees, depending on whatever money they are charging, right? Then preparing appeals, paper books, printing of documents, translation of documents. If let's say you have some proof to give, but the proof is in some other language, but the court only functions in English, then you have to translate the document and then give that copy. Somebody has to translate it. For that also money is required. A poor person may not have any penny, not a single penny. So any and every thing that you need in the court, everything you can think of in the court, is all provided by this NALSA, SALSA, DALSA, TLSC. Everything. Even if you want to get an A4 sheet to write an application, don't worry. The TLSC will give you that also. You want a lawyer? That also. In fact, just to tell you, now of course, if you say, sir, can I get Harish Salve? No, you can't get him, but they actually do have lot of lawyers who are impaneled. Roughly 50,000 plus lawyers are there. You have legal volunteers. So over 50,000 lawyers, 50,168 is the exact number, plus 40,000 plus legal volunteers. These are largely kids who are still in college, maybe law college, first year, second year students who are yet to practice in the court, etc. So these are paralegal volunteers. Okay. So it has a hefty number of lawyers and volunteers to help you out in case things go wrong. Are we clear what kind of service is being provided? Everybody? No doubt. Now the second question is that two eligible categories, and also the purpose was to provide a nationwide uniform network for weaker section. So who is a part of weaker section? A very important point is to know who is a part of weaker section. So the weaker section is this. These are the people who are eligible to get services under NALSA, DALSA, SALSA, TLSC, etc. All women and children. All. Please don't ask me if she is rich, then yes. All women and children. And just to give you a rough estimate of beneficiaries, so that you understand the importance of this entire structure. How many people actually avail the services of NALSA, SALSA, DALSA and all? As far as women are concerned and children are concerned, 2.2 crore women, 2.2 crore, and children 2.5 crore. This is just in 2021, 1 year. These many people got the benefit of NALSA, SALSA. Clear? Then members of scheduled caste and scheduled tribe, irrespective of their income. Are we clear? So scheduled castes, 77 lakhs. It's 76.9 lakhs, but 77 lakhs. And for scheduled tribes, roughly 28 lakhs. 28 lakh people got the benefit. Then transgenders, whose annual income does not exceed 2 lakh rupees. Around 14 to 15,000 of them also got the benefit. Industrial workmen, around 49 lakh such people got the benefit. Then victims of mass disaster, violence, flood, drought, earthquake, industrial disasters, all such things. Here also, roughly 6 to 7 lakh people who were these 6 to 7 lakh. Then disabled persons, people suffering with disabilities, roughly 27,000 such people got the benefit. Numbers not important. I'm just giving you so that you get an idea of the importance of NALSA in our country. The number of people who are actually getting help. Then people in custody, 2.2 lakh. Then victims of trafficking in human beings. Trafficking means buying and selling of human beings. That's called trafficking in human beings. So around 13 to 14,000 such people. And persons whose annual income is less than 1 lakh. Interesting, right? Uh, persons whose annual income is less than 1 lakh are eligible to get the benefit of NALSA, SALSA, DALSA. The real poor of this country. But just to put this point forward, The economically weaker section for reservation, the level is 8 lakhs. Yes or no? 8 lakhs. But when it comes to providing some benefit, actual benefit, right? Real terms, then we think, oh, sorry, then 1 lakh is poor. But when it comes to providing reservations, then 8 lakh rupees. In our country, 8 lakh rupees is a bit too much, right? With low purchasing power parity in our country compared to the Western countries, 8 lakh is very high as a limit. But anyway, this is also there. Around 83 lakh people got the benefit. Okay. I'll just solve a question quickly. We'll come back to the slides again. This question was asked in 2020 on the same concept. Easy question. In India, legal service authorities provide free legal service to which of the following type of citizens? Person with annual income less than rupees 1 lakh is correct. Remove this, remove this. 1 and 2 and 4. Let's look at 4. All senior citizens. Rajnikant is also senior citizen, right? In couple of years, I think Salman Khan will become a senior citizen. They don't need any free legal aid. So, of course, all senior citizens is wrong. Amitabh Bachchan is a senior citizen. So, this is wrong. Transgender with an annual income of less than rupees 2 lakhs, of course, is correct. A is the right answer. Uh, just to clarify a point here, this is not a very nicely framed question. I'll tell you why. Persons with annual income of less than 1 lakh, you know, this limit is only for few states. Other states have increased the limit. So, in some states, say the state of Andhra Pradesh, Assam, Himachal, Maharashtra, Tamil Nadu, Haryana. In states like Maharashtra, Himachal Pradesh, Tamil Nadu, etc., this limit is 3 lakh rupees. In states like, say, Bihar, in states like Rajasthan, this limit is 1.5 lakh rupees. But sadly, this has not been incorporated in the question, right? Had the UPSC ever taken some effort to look at the NALSA website, they would have obtained this information. But very poorly framed question, right? That's the sad part. Secondly, this transgender thing is only in Delhi. In Delhi, it's not there in other places. And one more thing, you also have the senior citizens who can get free legal aid. That's also there. For senior citizens, It's with income less than 2 lakhs. This is also only in Delhi, not in other places. So these are examples of poorly framed questions. So the paper setter did not even uh, think of looking into NALSA website before framing a question like this for the examination, right? But anyway, this is with respect to the eligibility criteria. Now, I hope you understand now that they provide legal aid and assistance. So here, all the people here whose annual income is in this bracket, you find out in your state, right? Uh, and in case in future you need to file any case, please approach the NALSA website. You'll get the link to your SALSA website. There you will get which district, which taluk to approach, and then you can approach there, get their help, file a case, etc. Clear? So that's the situation with respect to legal aid and assistance. Okay. Second, outreach programs. Of course, people at the ground level have to be made aware of those rights and laws. In most cases, people are simply not aware of what will they approach the court for. For what? You are not aware of your rights. So they have to conduct all these workshops, field surveys, etc., which is extremely important, right? So that's also a task undertaken by NALSA SALSA. To just give you an estimate here with respect to free legal aid and advice and counsel, 63.7 lakh people, these people were the beneficiaries. And this is just 1 year, 2021. Then legal awareness camps, workshops are set. So here also, in just 1 year, the NALSA, SALSA, etc., conducted over 11 lakh programs. 11 lakh seminars, online seminars, workshops, etc. Right? Then conducting Lok Adalat. So, what is Lok Adalat? We'll discuss it today only. Don't worry. I'll explain what is Lok Adalat. And ADR. What is ADR? ADR stands for Alternate Dispute Resolution. Lok Adalat is an example of ADR. What is this? We'll discuss shortly. Then social justice litigations. NALSA also fights a case. Its lawyers fight a case in the courts. A very good example of this social justice litigation is the landmark transgender case. In 2014, for transgender rights. In fact, NALSA won this case, and Supreme Court in 2014, NALSA versus Union of India. In this case, Supreme Court actually ordered the government that please provide reservation for transgenders in government jobs, which the government is yet to provide. Right? It's an order of 2014, which is yet to be provided by the government. Okay. One more interesting case with respect to NALSA was the uh, widows in 2012. Widows in Vrindavan. right? So for the widows who were suffering, again the Nalsa went to court, and the court issued orders to the state government to take care of the widows. So they also take part in filing court cases. Then outreach programs and preventive and strategic intervention programs. So in this, Nalsa runs a lot of schemes, right? So just to point out here, Nalsa schemes. Lot of schemes are run by them. For example, they have this scheme which is called Nalsa Legal Service to Disaster Victims, scheme of 2010, or Nalsa Victim of Trafficking and Commercial Sexual Exploitation scheme, or Nalsa Legal Service to Workers in Unorganized Sector, Nalsa Child Friendly Legal Service to Children and their protection. So whether it is for children, trafficking victims, mentally ill patients, etc., or even acid attack victims. Acid attack victims, etc. So various kinds of schemes are run. Okay. Traffic of victims, I just explained what is trafficking. Buying and selling of human beings, right? That is called trafficking. If you purchase some human being and take them to some other country, make them a domestic servant, that is called trafficking in human beings. So victims of human trafficking, right? Victims of commercial sexual exploitation, right? So schemes are run by Nalsa in those areas as well. Okay. So this is all that Nalsa does, the task that it performs. And of course, the funding comes from center. Center gives the funds, but it is of no, there is no interference from central government. It's managed completely by the organization Nalsa. Clear? Just to give an estimate, in 2021-22, funds around 145 crores were allocated to all the states. Clear? So this organization is, though under control of Supreme Court, still functions independently. It's an independent organization, though it is overseen by the Supreme Court. Are we clear? Overseen by the Supreme Court, but functions independently. Clear? This is NALSA. And look at the very important element of judicial independence now. So NALSA was one topic. A question has come from NALSA. We'll discuss that once we finish judiciary, right? And now the second topic, from which again a question came this year, is judicial independence. Very, very important. Judicial independence. Are we clear so far? Any queries on NALSA? Yes, Hussein. 37. How we have 29 states? Firstly, AS Hussein, we have 28 states. Firstly, not 29. Secondly, I clearly mentioned, I think, that some states have more than one SLS. And UTs also are there, sir. What are you doing, sir? Why? Where is the attention, sir? If you keep on typing statements, how will you focus on what I'm saying? Anubhav, sir, please. I just mentioned right now, the government gives the fund. From where will the fund come? Who do you think will give money? Government. Despite giving funds, the government does not control these bodies. These bodies are overseen by the NALSA only, Supreme Court only, boss. Okay. Anurag, SLSs are controlled by NALSA. NALSA is controlled by Supreme Court. That's how it is. See this structure here. I don't think it's difficult to understand. Okay? Structure. Vaibhav, NALSA case held in Supreme Court only or any court, but largely these NGOs, etc., file cases which protect rights of people or sometimes require the issuing of writs or require the protection of fundamental rights. So basically, these things can only be done in the High Court and Supreme Court. Lower courts have no power to cancel amendments to the Constitution, to cancel such laws in the country, or to even interpret the Constitution. The power to interpret the Constitution takes place only in the High Court and the Supreme Court. Simple. Okay? Anushka, sir, after retirement of senior most Supreme Court judge within 6 months, then who will be the executive head of? Madam, if some judge retires, there is somebody else just below the person who automatically becomes the second senior most judge. Yes or no? We have 34 judges in Supreme Court. There's a hierarchy there, right? So if the CJI retires, see what happens, guys. I thought this was self-understood. If the CJI retires, this person comes here automatically. So he becomes the patron-in-chief. Whoever was number 3 becomes number 2. It is automatic. Yes or no? The senior most Supreme Court judge becomes the CJI automatically. Which judge's case? Tell me. Okay, third judge's case. Not second or fourth, third judge's case. Okay. Now coming to a very, very important factor, which is judicial independence. Extremely important, of utmost importance, of key importance is the independence of judiciary. But my question to you is why? Why the hell is judicial independence so important? So see, very, very simple and easy to understand. Why is judicial independence so important? Uh, if judiciary is not independent, then who will keep a check on the parliament? Who will keep a check on the executive? Yes or no? So, the very first element is the need. Principle of separation of power, checks and balances between the L, E, and J. How can it ever be maintained if judiciary can be very easily manipulated by the government or by the parliament? How will the judiciary keep a check on these organs? Not possible, right? Secondly, if you look at the courts, especially Supreme Court and High Courts, even the lower courts, you will find that most cases are where government is involved. Government versus somebody, you versus the state, you versus the country. In most of these cases, in more than half the cases, executive is one litigant. If the judiciary is not independent of the executive, then remember that I gave the example, the NJAC problem, same old story, that if they are not independent, what's going to happen? Every judgment will come in the favor of government only, against the people, right? That can be a big problem. So we have to have a separate and independent judiciary. Then rule of law. Rule of law. What is rule of law? Rule is not of people. Rule is never of a party. Always understand this. Rule is always of the law. Meaning, whoever comes to power, his task is to implement laws. Ultimately, it's the laws which are enforced on the people. Maybe in the medieval times, we had a phrase called rex lex. King is the law. Whatever the king said became the law. But now it's lex rex. Law is the king. In fact, law is the king of all the kings. Today, BJP is in power. Tomorrow, some other party can come into power. It does not really matter. All those parties have to implement laws only. And every party, every government is bound by these laws, these rules, regulations, the constitution, right? That is what we say is rule of law, which means limitation on the powers of the state. State's power is limited, right? And who will keep a check on this? The judiciary. The independent judiciary will keep a check on the state's powers, right? Rule of law. Then we are in a democracy. Now, in a democracy, majority of the people have voted and they have chosen what? Majority has actually voted and chosen the parliament, the government, executive, right? The parliament and the government represent the majority. But then who will represent the interest of minorities? To represent the interest of minorities based on religion, minorities based on caste, minorities based on language, sexual minorities like transgenders, who will protect their interest? They are not a viable vote bank, small group of people, right? For the larger majority, it's the court, it's the government, right? Because they will focus on those who have chosen them, right? Vote bank politics. So these will be protected by the courts. And if courts are not independent, how will the minority rights be protected? The democratic rights of minorities can only be protected with an independent judiciary. Otherwise, our country will become the play tool, the tyranny of the majority, the play tool at the hands of government, which will do what it feels like. And lastly, look at our constitution. So far, you have seen so many provisions, but you would know that we have a very centralized kind of constitution. Center is very strong. More on this later on also. Center is very, very strong compared to states. And states and center, they constantly come into conflict. State center controls all the resources, right? Armed forces, etc. Today, if some state is acting over smart, what if center says bomb the state, missile? State has police with their amazing rifles and superb training of the constable, right? And center has the armed forces. So without demeaning the police personnel, you are no match to the armed forces training, right? States don't have their own missiles. So the idea here is that center state disputes have to be resolved peacefully, amicably. Who will resolve it? The courts, to preserve the norms of federal polity. That is protecting state's interest. So for this also we need an independent judiciary. Okay, are we clear on this, everyone? Right? Okay. Now, in the constitution, you will find that there are plenty of provisions which ensure the independence of our judiciary. For example, these things. So yes, at least for the Supreme Court and largely for the High Courts, you'll find that we have tried to ensure independence. Number one, in appointment. Don't we have a collegium system now, which is a bit too independent? I mean, there is no check and control only. Removal. Removal is extremely difficult. I mean, so difficult that not even a single judge has ever been removed. Ever been removed from the High Court or Supreme Court. One more thing, the conduct of a sitting judge of the High Court or Supreme Court cannot be discussed in the Parliament or the state legislature. This is Article 121. This is for the Parliament. There is a corresponding article for states also, 211. Meaning, in the House, you cannot discuss the conduct of the judges. Are we clear? That would amount to breach of which kind of motion can be raised? If you discuss the conduct of judges, which is not allowed, tell me which kind of motion can be raised. Very good, guys. Privilege motion. Excellent. Some of you are writing some other motions, but the answer is a privilege motion. Privilege motion is when you are breaching the privilege of the House. You have been given the benefit to speak freely. The MPs have the unfettered right to speak in the House. Yes or no? The MPs will not be inquired. Whatever you say, whatever vote you give, will not be inquired into in any court of law. Right? Which article says so? Kavanna, Krishika, BK Vibhu, Raja. Others given up. Where is the revision? Article 105. Right? Answer my question first. Safely avoiding what I am asking and writing useless things. Anyway, so when you discuss the conduct of a judge in the court, then what happens? It's a breach of parliamentary privilege and a privilege motion can be raised. Don't write contempt motion and all. There is no motion called contempt motion. Please don't make such statements, right? Talk like you have taken some class in polity, ever at least. So that's it. Then they are debarred from practice in future. Yes or no? Are they debarred from practice in future? Which article for Supreme Court says that they are debarred from practice in future? Tell me. Okay, great. This is Article 124, Clause 7. Okay. Then their salaries, their allowances are charge expenditure. What is charge expenditure? Voting in the parliament is not allowed. It has to be approved directly. Discussions can take place. Then the Supreme Court, the High Courts, they have power to make their own rules. Article 145. They make their own rules, right? And contempt power also. If you make any kind of derogatory statement against the court, or if you don't follow court's judgment, they can also issue contempt notice against you. So this is under a separate law, which is called Contempt of Court Act. We'll discuss this under fundamental rights. Don't worry. Okay. Yes, Hussain, you are writing 142 for everything. Any question I'm asking, you're writing 142. What can I say? That's why I say, sir, attend classes regularly, right? Revise regularly. Okay, so these are steps to ensure independence. Ashay, revise. Okay, revise. Because in the same group there are other people who know these articles. This means they are just revising it. Rather than wasting time, they are revising it. Okay. Ananya, Attorney General also has his power. No, no. It's different. We'll discuss that under fundamental rights. Don't worry. Now solve this question. Mark the answer. Let's see how many of you get this correct. 45 seconds to mark the answer. Please mark your answer. Okay. Now, while appointing the Supreme Court judges, the President of India has to consult CGI. Yes or no? Yes, of course. One is correct. Remove this. Remove this. The Supreme Court judges can be removed by the Chief Justice of India only. Is it correct? Of course not. The Supreme Court judges can be removed only by the Parliament. 2 is wrong. Anyway, this is also wrong. We have the right answer. Let's look at 3. The salary of judges are charged on the CFI, to which the legislature does not have to vote. Absolutely correct. All appointments of officers and staff of the Supreme Court of India are made by the government, are made by Supreme Court after the president's approval. A formal approval of the president is required, and the court makes its own rules. So this is also wrong. Clear? Salary from CFS, Urmila. The question is about Supreme Court. Read the question. Okay. Rahul, please explain. Legislature does not have to vote. Really? Sir, charge expenditure from CFI. There is no voting on that. Please don't ask me to explain what is taught in the second class here. Come on. Appointment of Supreme Court is from the Parliament, Puja. Appointment is from Parliament. What is happening to some of you? Why? Sir, I chose. Anyway. Now let's come to the issues concerning judiciary, and in those issues, the very first issue is what? The pendency of cases. Cases are pending in the courts, right? Tariq pe tariq, dates after dates. This scene is a legendary scene from a very old movie, around 30 years old, Damini, starring Rishi Kapoor, the late actor Rishi Kapoor, Ranbir Kapoor's father, Sunny Deol, and Meenakshi Chaudhary and then Amrish Puri, etc. 30 years ago, Sunny Paji was very angry, saying that the court only gives dates after dates. But still, the same old story. 30 years down the line, nothing has changed. It's still the same. Dates after dates. How many cases are pending in the Supreme Court? So, number of pending cases. When you make all these allegations, we need to also mention the pending cases. Currently in the Supreme Court, if you also include those cases which are just filed, not registered yet, some of them will be registered, of course, most of them. In the Supreme Court, as per their current data, 80,000 cases are pending. 80,458. Right? These are the number of cases pending in the Supreme Court. Let's go to the High Courts. In the High Courts, over 60 lakh cases are pending. 60.77 lakh cases. You can simply say 60 to 61 lakh cases are pending. 6 million cases are pending. Okay? 6 million cases. And in the lower courts, the subordinate courts, here 4.44 crores. Crores. So just to summarize all this, total 5.06 crore cases are pending. Yes, you are hearing me right. This is not a joke. 5.06 crore cases. Over 5 crore cases are pending. Let me just give you an estimate of those cases which have been pending for a long period of time. So, those pending for 3 years or more. In the High Courts, almost 61% cases are pending for over 3 years. And in the subordinate courts, this number is slightly better, 42%. So, in the High Court, please rest assured that you will have at least your case being heard after 3-4 years only, not before that. One more thing, just to mention this point also. Cases pending for more than 30 years. In our country, there are around 1.7 lakh cases which are pending for over 30 years. Both in the lower courts and the high courts. In lower courts, it's around 98 lakh cases. In high court, it's around 71-72 lakh cases. Pending for more than 30 years. For 30 years, justice has not been done. Where is the efficiency? One more thing, just a very interesting piece of information. So back in 2018, this body called Niti Aayog was very enthusiastic in conducting the studies on how to solve these pending cases. So Niti Aayog published a report. Those who don't know what is Niti Aayog, we'll discuss this in your economics classes. So just understand there is a body called Niti Aayog. That's it. This Niti Aayog said that in their report of 2018 that at that point of time in 2018, then 2.9 crore pending cases were there. So pendency has just doubled in the last 5-6 years. Now, Niti Aayog said that to resolve the backlog. What is backlog? Those in college would know. When you fail, the papers are not cleared, it increases your backlog, meaning pending cases. To resolve the backlog, meaning pending cases, how many years are required? Niti Aayog said it's very, very easy to clear all the pending cases. It'll take just 324 years. That's it. 324 years. When the pending cases were 2.9 crores, now it is 5 crores. So you can very well understand that maybe in 500 years, all the cases will be resolved. And mind you, this will only happen if no new cases are filed. If you keep on filing new cases, then there'll be a problem. Are we clear? If you keep on filing new cases, then this will never be resolved. Because currently, the case clearance rate in the subordinate court is not over 100%. It's 90%. Meaning what? Every year, 100, if 100 cases are filed, only 90 are resolved. Are you clear? This means every year you're getting additional backlog of 10 cases per 100. So the backlog is only going to increase, right? So that's how it has been the case. It keeps on increasing. Now, to cut a long story short, and there are some high courts, again, high courts like Allahabad High Court. Allahabad High Court alone has 10.5 lakh pending cases. Bombay High Court, more than 7 lakh pending cases. Then some high courts like say Sikkim High Court, it has only 151 pending cases, right? Now the point here is, so what? If there is pendency, what happens? It's okay, no problem. Tell me, what is the adverse implication of pendency? Right from our childhood, you have been hearing this statement: justice delayed is justice denied. Of course, too little, too late. So that is always the case. We understand it. Beyond that, if there's excessive delay in the delivery of justice, how else are we going to no, or what else are going to be the implications of it? And mind you, Supreme Court slogan is, where there is dharma, there will be victory. We don't know where dharma is and where victory is. Maybe victory is only in the houses of rich and elite people, but not for the poor and deprived sections, right? So, first things first, it does waste the resources. You keep on giving dates after dates. It wastes the resources, yes or no? The resources of the court and the people, and the resources in the form of time plus money, both being wasted. Also, if this is a situation, then how will people have any kind of faith how will people have any kind of faith on the system? This leads to erosion of the image and the credibility of the judiciary, right? People will no longer have any faith in the system. And this can also increase the tendency of criminality in society. Let's see, I will commit a mistake. So what? I can hire a hotshot lawyer and get the case delayed year after year. That's what rich people do, right? Delays. They never get punished. That is why there's a big misconception that severe punishments are the biggest detriment. No, no, no. How severe the punishment may not be a very big detriment, but how certain is the punishment is a bigger detriment. And the problem is that we are focusing excessively on severity of punishment, but there is no guarantee of punishment in this country. And that is why it has come down to a situation where people rejoice encounters. Look at some of you here would say, yes, sir, encounter is right. Look at how the society has made you believe that killing people without the courts finding them guilty is now okay for people, because we know the meandering pace of justice in this country will make sure that the rich and elite will escape the clutches of the law and things go wrong. And now we are becoming slowly comfortable with the idea of encounters, right? That's a very sad state of affairs, that it's now calming to people that yes, it's okay. Beyond this, one more issue. Now, think of a situation: you go to a bank, you get a loan, don't repay the loan. What will the bank do? File a case in court. You know very well, court, case in court. You say, come on, bank, thumbs up, great, go and file a case, because you are very, very confident of the amazing judiciary. And if by the time the case comes, you'll be dead already, right? So no problem. But look at all these private financiers, the private money lending companies. Look at them. They don't go to court and all. They hire all these protein powder fed people, right? If you miss an EMI, they'll come to you and they'll say, money please. And they'll ask you very, very nicely, these bodybuilders, that you'll not just give one installment, you'll give the next 10 installments also. What is that? You are only increasing the tendency of the people to employ extra legal means to solve the problems, because people know what's the point of going to court to file a case, right? There's no point. I can't wait for justice for 10 years. I run a private financial company giving loans to people. I can't go and file a case and fight a case in court for 10 years. It's wasting my resources. So, come on, bodybuilder, go teach him a lesson. Get my EMI. 10 EMI, sir. Take it. Okay, that's how it is. Also, recently, Supreme Court came down heavily on the government, that government is not taking care of prison population properly and prisoners are suffering because there is overcrowding of jails. What is that? Overcrowding of jails is happening. Now, my point is very simple. If the my lords ever had the time to look into any kind of data, they would come to know that the reason for overcrowding of jails is under trial prisoners. High under trial prison population. Who are under trials? Do you know who are under trials? So, in the jail, you have two types of people. One who are called convicts. The court has found you guilty and you are serving your punishment, a convict. But for other people whose case is still pending in the court, The date has not come, the judgment has not been given, they are called under trial. For them, the bail was not given and they are out, or they are inside the jail because there is no bail for them. They are not held guilty. Are we clear? They are yet to, the court is yet to find them guilty, but still they are in the jail. Out of, in 2021, the total prison population was 5,54,000. Out of these 5,54,000, 77% are under trials. Of total prisoners. Imagine, in most of these cases, they may not be found guilty, right? If you remove 77% people out of 5.5 lakhs, that means 3/4 of them are going away, right? We'll end up with 1.5 lakh people in the jail. Our jails can very easily sustain and manage over 3 lakh people. Our prison population will come down. But because the courts are not taking cases quickly, there's huge pendency that we see overcrowding of jails. And it's just a violation of the human rights, nothing else. So these are the adverse implications for the Indian citizen. But a bigger question is, how did we arrive at this situation? This is a result of what? So, what do you think are the reasons for pendency? Tell me, what according to you are the reasons for pendency? Okay, so some of you are mentioning the same points. First things first, if you look at the reasons for pendency, the total sanctioned strength is very low. In our country, we have how many judges? 34 plus 1114 plus 25129. 25129. Just these many judges. That's it. That means 277, 26. Roughly 26,277 judges, right? 26,000 judges, right? Look at a country like China, 2 lakh judges. And then look at the Indian population, 142 crore people and 26,000 judges. Judge to population ratio is very poor. So in other countries, say USA, it's 150 plus, China, it's 300 plus. In India, the judge to population ratio is around 18 to 20. India, it is 18 per million. Million means how much? 10 lakhs. For every 10 lakh people, we have around 18 to 20 judges. If you take the 2011 census, it will be 21 judges. But if you take the current population, it will be 18 judges. 18 to 20 judges for 10 lakh people. In USA, it's 150. In China, it's 300. Of course, we don't have judges only. Population is too large. And to top it all, we also have vacancy. Vacancy at every level. I mean, even at the Supreme Court level, 2 seats are vacant out of 34. High courts, 340 seats are vacant. 340. 340 out of 1114. That would be roughly 52. 30.52%. 30%. 30% seats are vacant in the high courts. Same goes for the lower courts. The subordinate courts, around 5,750 seats are vacant. 5750 seats out of 25129. It's around 23%. Right? That's the situation. Around 23%. This is the vacancy in the judiciary. Of course, we'll have a problem. Right? Then, one more interesting point that some of you would know is, of course, this fact that in our country, the allegation that Supreme Court has too many holidays. Too many holidays. Right? For example, Supreme Court has summer vacations. Supreme Court has summer vacations. Like a small school kid, summer vacation. 45 days of summer vacation. Winter vacation, 15 days. They have 1 week of Holi. Who plays Holi for 1 week? Right? How free are you to play Holi for 1 week? Dashera, Diwali for 5 days. This is too much. Dashera, possible. Diwali, 5 days holiday. Okay. So that is one problem. The lesser number of sittings in the courts. Supreme Court around 190 days per year. High courts around 210 days per year. Now, let me also clarify one thing here. This may be a reason, but this cannot be removed actually. So holidays can't be removed. Don't be angry and upset. Just hear me out. Just a sec, guys. Just a minute. Okay. So as I was saying, see, the judges in the courts, they preside over multiple cases every day. Various lawyers come, throw in their argument, quoting this judgment, that judgment, this law, that law. The judge has to go through all that, has to write his own judgments, etc., how he arrived at the judgment, giving reasons, all these things, which can run into hundreds of pages sometimes. It takes some time. So basically, in their holidays, judges don't go and enjoy. They don't go to Amsterdam and Goa and Maldives and Bali. They are sitting in the home studying only, right? So that may not be, that cannot be increased. Though I'll come to this also, how to improve this problem later on. Later on. Now, okay. Then what else? Other things, like we have this growing culture of adjournment of cases. Case adjourned, next date given. Very easily, next dates are given. Tariq pe tariq. That's also a problem. Then the very poor quality of investigation and prosecution by the police. Poor quality of investigation and evidence collection. So that also is a problem, that at the state level, because police is controlled by the state, the police, the lower level staff, right, they are hardly trained, right? So of course that becomes a concern. The quality of uh, evidences that they collect is very shoddy, right? And they will always want more time in the court to collect more evidences, better evidences. The case keeps on dragging on and on. Then we also have very old laws, because our laws have been very, very old. There are so many procedural complexities in the laws. So old laws full of procedural complexities. Look at the example only. IPC is of 1860, right? Indian Evidence Act is of 1872. Indian Police Act is of 1861. The Code of Civil Procedure is of 1908. Old laws. You can Google search for the full form. You write this and the date, you'll get the full form. Don't worry. Okay. So that's also a concern. Then filing of frivolous cases. What are frivolous cases? Silly, useless kind of cases being filed here and there to harass the people, right? And also nowadays it's very, very important for people to become famous, right? One easy way out is to file some kind of silly case somewhere against the person, and that's it. Sit and enjoy now. The case drags on and on. Just to get famous, you have to come to the limelight, file silly, stupid cases. That's also a concern, right? Now, one very, very important challenge that you need to understand is the very poor quality of infrastructure. Poor quality of infrastructure at the lower judiciary, not in the High Court and Supreme Court, of course, but at the lower judiciary level. You'll be surprised. So, you need not mug up all this data, just roughly, but I'll give you some information. In 46% of the lower courts, there is no purified drinking water facility. Meaning, bring your own water bottle, right? Then, in 68% of our lower courts, no separate record room where records can be kept separately. No, it's not there. Records are kept besides the judge only. A small dingy room, one tube light, one fan facing the judge, broken tables, nobody dare to sit or else they'll fall down, right? And records kept here. So easy, anybody can walk in, tell the judge, Judge, look that side a bird. Judge looks, record stolen, gone. Simple. Misplaced records. This is how casual the records are being kept in the courts. Then, so we are talking about libraries and computers. 63% of the lower courts do not have computer on the judges table. No computer. Even some of the most basic things, Swachh Bharat Abhiyan, if you don't have a functional toilet, you cannot contest panchayat elections. 26% and 16%. No ladies' washroom. No men's washroom. This is the situation. How will the judge ever be inclined to focusing on giving judgments? He comes at 10 o'clock. He comes at 10 o'clock and wants to run away. Can't drink water, not available only. Can't go to washroom, not there only. Right? I mean, don't even have library in the court complex. How will the judge refer to various laws? He cannot, because see, law books are very costly. Don't think Lakshmikant is the best legal book. It is not. Just a very simple book, D.D. Basu's book, not the one you have purchased, the yellow one. No, not that one. D.D. Basu's shorter version of Constitution in 2 volumes. That alone costs 6,000 rupees. There are hundreds of laws, so many books. Judge has to refer to all these things. His judge at the lower level has a very basic salary of a government employee, same salary. Don't expect him to waste so much money on this only. That's there. And of course, then at the lower level, there is also the allegation of corruption. So please always write allegation of corruption. You don't know. Allegation of corruption and mention at the lower level. Now see, allegation of corruption is there at the higher level also. But why should we quote all these things? One former Supreme Court judge, Justice Kardju, had once mentioned that Allahabad High Court is a den of corruption. But he has no data to quote this, and we can't quote his statement. You may say that retired judges have made several such statements about the high levels of corruption in the high courts also. There is no proof of it, but still, lawyers like Prashant Bhushan, they have claimed that almost every judge is corrupt. Now again, that's a bit too much, too far-fetched. But still, there are allegations, right? So these things are there. Very simple. At the lower level, how does this system work? Very simple. Today is the last day of hearing. I am a lawyer. I know very well that the case will close today, and I am winning the case. My client will be free. My client is yet to pay me the fees. Some fees is left. I tell the judge, Judge, my lord, can I approach the bench? So I'll go close to a judge and tell him, my lord, give the next date. If you give judgment today, this fellow will run away. And I'll then keep on chasing him for my fees. So, next date. By the way, I heard you were looking for a nice 4 BHK flat in that society. Let me know, sir. I have some contacts. Done. Adjournment. Next date given. So there are allegations of these things happening in the courts. So multiple reasons of for pendency. Now, just one point here. I'll mention one suggestion here only. So for this, center has now said that they are willing to devolve funds. So center will give around 5,300 crores, and states will contribute the remaining 3,700 crores. Okay, this will be used to be used to improve the infrastructure. In fact, they have started this program called Nyay Vikas, in which it's an online system where they are geotagging the assets. So if a toilet is built somewhere, they'll geotag it that, okay, yes, in this court now a toilet has been built. A water purifier is installed, geotagging that in this court a water purifier has been installed. But again, the states have no money only, right? The states' money is being spent in giving people what? Juicer mixer grinder, right? Free this, free that, free everything. So if all your money is spent in fulfilling your poll promises of freeing everything, even for the middle and upper middle classes, then where will you have the money to improve the infrastructure, right? So that is again a problem for the states only. But anyway, this area is being looked into, though it is very slow and tardy, right? It's not a high level of enthusiasm from the government side, because ultimately courts don't have revenue generation power. Courts can't make money. They have to depend on center for funds, and center will keep on giving some excuses. States also that no money only, what to do, all the money is spent, and that's true. Most states are running in this deficit. Forget fiscal, they are in revenue deficit. Imagine the poor financial management done by states. So more on this in your economics classes, and you'll be aghast at how poorly maintained the state's finances are in most states. That's a sad story. Anyway, uh, one more, though I would not say it's an issue, is the rising levels of literacy in the country. Now that is also contributing to pendency. So a few years back, one of the milords said that, in our country, people love to file cases. There is docket explosion, meaning explosion of filing of cases. We have to tell the milords that it's not true. In our country, still lot of people do not have the avenue to file a case or knowledge to file a case. If we compare this to, say, a developed country like, say, USA, in India, 17 cases are filed per 1,000 people. 17, 1, 7, 17. In USA, the number is 330 per 1,000 people. With rising levels of literacy, you will only witness more cases being filed. Just to give an example, this study was conducted between states like Tamil Nadu and Bihar, Jharkhand. So it was found in 2012, 10 years ago, that in a state like Tamil Nadu, for every 1,000 people, 12 civil cases were filed. 12 civil cases. In Bihar, Jharkhand, this number was as low as 0.5. Imagine now, with more education, high literacy, the states will keep on filing more and more cases, or the people will file more and more cases, which will add up to the pendency. Right? So we are yet to witness the full capacity of the citizen to enjoy his or her rights comprehensively. Right? That's the situation. Anyway, let's do one thing. Let's take a break. After break, we'll look at what steps can be taken as corrective measures to solve the problem of pendency. I'll put at this slide only. So break, please. Come back at 7:05. This is for the lower courts, not for Supreme Court High Courts. Break, please, guys. Welcome back, guys. So, before the break, we were discussing about the reasons for pendency. Now, we'll look into the corrective measures. What steps must be taken? So, what steps must be taken to, keep a check on pendency? Tell me, what steps must be taken? Appointing more judges, of course, of course. What else? Funds, filling a vacancy, fixing time frame to give justice. How to fix time frame to give justice? That may not be a good idea. Okay. So largely, all of you are mentioning the points which go along with the problems that we have. Let me just collect all those points. Amazing, great contribution. So, of course, we have to increase the sanction strength. Increase the sanction strength, meaning the increase the judge to population ratio. At least 50. 50. This has also been a suggestion of the Law Commission in its 120th report in 1987 to increase the population ratio, judge to population ratio, to at least 50 per 10 lakh people. Also, filling up of the vacancies, right? Now, this may not happen overnight. It'll take some time. We cannot simply hire judges suddenly, because that may compromise on the quality of the judge. That's also there. One, of course, a point would be to improve the infrastructure, then revamp the old laws or replace the old laws. Also, use of ICT, increasing the use of ICT. What is ICT? Information and communication technology. For those who do not know this, we had discussed this earlier also in the topic panchayats and municipalities, ICT. So, use of information and communication technology, firstly, with respect to di- digitization of records. Secondly, also with respect to virtual hearings, online court hearings, right? Then capacity building, capacity building of the police personnel. Personnel, not personal. Personnel means staff. See, when it comes to these policemen at the lower level, you have to also understand that they are in a very difficult situation vis-a-vis their day-to-day activities. For example, it's the same police constable who has to be the first person to reach the scene of the crime and is expected to collect forensic level evidence, right? Without any training, mind you. The same policemen also need to manage your political rallies. The same policemen also have the task to maintain law and order. The same policemen also have to ensure in case of riots things don't go wrong. The same policemen also have to bring vegetables in the house of the big sahibs, the SPs, DIGs, IGs, right? Take their kids to school, spouse to work, etc. Right? So how will they perform the activities properly without training? So to collect evidences which can be used properly in the court, you need to get trained properly. That's it. Now, apart from this, we also some of you may say, sir, we have too many holidays. So as I said, reducing holidays is not possible, right? But what we can do is spread the holidays throughout the year. Meaning, see, every judge needs some time to study and stuff. We fully agree. But when the entire court goes away in vacation, then there is suddenly a huge piling up of cases, which becomes difficult to solve. So, what we can do is we can spread the leaves throughout the year. Spreading leaves or holidays throughout the year. Meaning, before the beginning of every year, right? You simply ask the judge, when do you want your 1 month of leave? Or when do you want your 45 days of leave? Some judges can take a leave in January, some in February, some in March, so on and so forth. And in this way, the Supreme Court functions throughout the year without any big break. And the concerned judges also get their leaves where they can study, plan accordingly, etc. Right? So that's a better step to do. And this spreading of leaves, the term used is called staggering of leaves. Stagger. Clear? Then, one more thing. When it comes to the judges, and especially when it comes to the pending cases, see, there are some cases which are more than 30 years old, more than 20 years old. It's a shame on the judiciary that this is how long a case continues. So at least we can set up fast track courts for solving backlog or pendency. Now, what exactly is a fast track court? Let me explain this. Fast track court is not some unique kind of court which is created separately. It's a regular court, a normal court. Think of it. There is a judge sitting here. Now, in front of the judge, you can file any kind of case depending on what power he has, right? If it's a sessions court judge, you can file a criminal case, a small, big, any kind of criminal case. Anyone can file it, right? But what we want is to segregate, pick and choose the old cases. So we'll appoint a special judge and we'll say that this in front of this judge, only special kind of cases can be filed. And what should be the criteria? The criteria is, say, all the cases which are more than 30 years old. So in front of this judge, you cannot file any other case. That is an example of a CBI court, NIA court. What are those courts? Is CBI running a court? It's silly to think of it. CBI court is a regular court. The only condition is that in that court, in front of that judge, only CBI will file a case. So a special judge is allocated to take up all the cases filed by CBI. This expedites the matters. Otherwise, if the CBI also gets the access to regular courts only, then all the cases filed by CBI will be all stuck along with other cases, some silly cases, some important cases. So we have to segregate those cases and we have to allocate those cases to a judge and say that in this front of this judge, only these cases. Those are called fast track courts. Clear? So this is an example of a FTC fast track courts. Did we understand what is a fast track court? Was somebody sleeping at this point of time? Were you all awake? Okay, great. I'll just repeat this once again. I'm not sure how to say this differently, but still I'll try once again. Coming from those who have attended the class after 3-4 times, I find your names in 4-5 batches, and then you ask me repeat. Anyway, there are 1,000 crores of cases in the lower court. I want to find out those cases which are say 10 years old, 20 years old, 30 years old. What I'll do is I'll firstly solve those cases. How to solve those cases? Segregate those cases. In the lower court, appoint one special judge. Judge is there. We simply tell the judge, now you, judge, come here, sit. In this room, in this court hall, in front of this judge, only those cases will go which are say 30 years old or 20 years old or 10 years old, etc. That's called a fast track court. It can be set up for anyone. It can be set up for any person. There can be a fast track court for politicians only, meaning all those cases where a politician is involved will be heard before. Or there can be a fast track court for women. There can be a fast track court for sexual crimes. There can be a fast track court for cases against children. Are we getting this point now? Everybody? Yes, these number of cases are limited to lakhs of cases. Okay, to lakhs of cases. What specification is, Hussain? Now, what is the concern? Anyway, beyond that, we can also take a step of exploring alternate dispute resolution mechanisms. Okay. Now, a very good example of this ADR would be Lok Adalat, Gram Nyayalaya. Okay. We'll discuss these terms shortly. These are the steps that can be taken. Kushagra, but sir, if we have vacancies in the court. Now, Kushagra, I'd ask you only, what do you think is more important? solving a case, let's say the case is about some kind of crime of a similar nature. What is more important, solving a case filed today or solving a case pending for 20 years, right? So what we're doing is, of course, the first priority is to increase these, but other steps also need to be added. Or should we say the only priority is filling up vacancies and increasing judges? Increasing judges cannot happen overnight, right? You cannot hire 10,000 judges tomorrow only. That will compromise the quality. This can only happen in a very long period of time. In the meantime, we have to do these things also, right? Are Vidya, yes, 20. Oh, of course, yes, yes. Correct, Vidya. Of course, correct. Vaibhav, I cannot exactly put a number to it actually. That's also possible, Divya. No, Rani. No, no, no. Prem Kumar, case tracking is there. It's already there. That's why I'm giving you all these figures of pendency. No, Lakshmi, you can write your own points also. Simple. Lakshya, delay is due to kind heart, we think. No, not we. You think. Don't take it on other people. So one of our aspirants says that innocent must not be punished. It is the kind-hearted nature of our judges that causes delay. Okay, that's very sweet and innocent of you, but that is not entirely true, sadly. Anyway, yes, yes, Vidya, we already have fast track courts which are there. We have currently 400. Okay, let me write this. Currently, we already have 489 such courts in 19 states and UTs. Okay, it is already there. Yes, Soumya, that may also be possible. Why will ARC give a session here? AS Hussain. Prem Kumar, administrative and political influences are only limited to lower courts, not to high court and supreme courts, especially not in high courts, right? So for that, more independence for the judiciary at the lower level, that is a step in this direction. Pranav Mishra, I think your question was answered that it does not. Okay. Now let's move on to understand what exactly is a Lok Adalat, right? So let me explain first what is a Lok Adalat, and then we'll have a discussion on the elements of Lok Adalat. Think of a very simple example. You go to a bank and take a loan, say of 90,000 rupees. Now the bank starts charging interest. Slowly, with interest, your loan becomes 1 lakh rupees. That's your loan outstanding amount. Now you stop paying the EMI, the equated monthly installment that you pay, the loan repayment that is being done on your part, you stop it. Okay? If you stop the repayment of loans, then what happens? Your loan is categorized as a special mention account in the by the bank, that this fellow will not return the money. After two missed installments, your loan is called an SMA type 2. After three missed installments, the loan is called NPA, non-performing asset. 90 days of delay in the installment being paid. Now, the bank takes it seriously. Slowly and steadily, if you still don't repay the money, that loan becomes a doubtful asset. It's a substandard asset actually for the bank. It's doubtful, and finally it's lost asset. Bank after 2 years says, well, this fellow will not return the money. Move it outside the books. Let's accept it as loss only. But the bank, to maintain its books properly, has accepted the loss. But the bank has not ceased to have a claim over you for the money. You have to still pay the money. Now, see, the bank can always go to the courts. The court's doors are always open. The bank can approach the court and file a case. Let's say the bank has filed a case in the court. Now, when you file a case in court, you require a lawyer, hearings, 1 day, 2 days, 10 days, court fees is there, 1 year, 2 years, 3 years, the case can go on and on. Now, bank thinks of an idea. Bank says, let's do one thing. Compromise. Compromise. Meaning, bank sends you a letter. In this letter, the bank says, shameless fellow, you have not sent the money and all. But don't worry, we are giving you a discount. Your total outstanding is 1 lakh rupees. I am giving you a loan waiver or a loan discount or a haircut of 20%. Meaning, you please pay the remaining 80,000 and we will remove your name from defaulter list. Go. Discount. Now, this letter comes to you. The bank says, if you are willing for this, please come on that particular date on this month to the local court, address is mentioned, and we'll go for a compromise. If you are willing that, okay, nice, it's good. If I pay only 80,000, my name will be removed from the defaulter list. Great. So on that designated day, you can go to the place where the Lok Adalat is being conducted and go for a compromise. Normally, the permanent Lok Adalat is conducted on the second Saturday. Like in 2023, it is being conducted, or it has been conducted in the past, in the month of March, the second Saturday of March, in the month of May. Then it was done in September, just recently, 9th of September. 9th, I think, yes. And then we'll have it in December also. So on this date. So what do? You go to the Lok Adalat. This lady, this man, maybe a couple, I'm not sure. Let's not make any kind of relationship between them. They may not be a couple. So they go, maybe they are defaulters. They have taken money, but did not return the money. So they were called and they agreed on the compromise. They have come. This fellow, an angry looking fellow, is the chairman of the Lok Adalat. He is normally a retired district court judge. Okay. Then there are other two people also. This fellow and this fellow here. These two. These two people are not judges. They are experts in the area on which the case is. So maybe there are some retired bank officials, or maybe people who are experts in the financial part of things and all. Social activists, such kind of people. There's this person who is calling out names. So this person's name came. There are some over enthusiastic people who are, that's always the case, trying to see where their name is so that they can go and have a cup of tea if their name is too down the order, right? Then this fellow, looking at by the looks of his sad face, he must be the bank's lawyer. Bank also has a lawyer, so he also comes. So this is a current situation. Now these two people sign that, okay, I am signing. The bank's lawyer signs, compromise done, case resolved. Done. Imagine the bank had to go to court and file a case. The case would go on and on forever and ever. So if the compromise is done, the bank can take out its case from court. At court, sorry, problem solved. Give my case back. Simple. Or the bank can go to the Lok Adalat first without even going to court. So court's window is always open, right? The door of court is always open. Whether you go to Lok Adalat or not, it's your choice. Simple. This is what is a Lok Adalat. The idea is peaceful, amicable, peaceful settlement of disputes through a compromise. Both parties have agreed. So the beauty is it's flexible, it's affordable. These people, did they have to hire a lawyer? No need for any lawyer. Then it is fast, quick, on the spot. It is also final, and finally it is amicable, peaceful. Clear? So Lok Adalats, again under the same law, Legal Services Authorities Act was amended to provide for permanent Lok Adalats to deal with cases pertaining to public utility services. What kind of services? Services like bank loans, services like electricity bill, water or electricity bill, services like traffic challan, fines, or even for matrimonial disputes. Of course, except divorce, okay? Not divorce. Are you clear? Not divorce. Divorce or any domestic violence case, no, that can't be solved in Lok Adalat, you know. These are meant for basic civil cases and very small compoundable criminal cases. I'll come to it shortly. So these are the examples of cases that can be dealt with by the Lok Adalats. See, this concept of Lok Adalat has been suggested by Justice P.N. Bhagwati, right? And the first ever Lok Adalat in the country on the 14th of March 1982 in Gujarat, Junagadh, right? That was there. Now, as I said, a permanent Lok Adalat shall consist of three people. One is the chairperson, who will be a former or serving district judge, or an additional district judge, or a judge having held judicial office higher in rank than that of district judge. So normally a serving district judge will not have time. A serving district judge will not have time. So normally retired district judges come and sit and preside over these cases. Are we clear? Pihu, what is permanent Lok Adalat? Lok Adalat which is conducted permanently. Every year you have 4 days in which Lok Adalat is held. And that's a permanent Lok Adalat. I think you have not understood the point, couple of you. Some of you are saying that Lakshmi says that how many Lok Adalats do exist. But madam, these are not some courts which continue forever. I am saying on specific days, people are called to a place. If they want to do a compromise, they can come and a compromise can be done. That's it. On that day only, not a day before, not a day after, right? So this is what is called a permanent Lok Adalat. There is no temporary Lok Adalat. Please. Kumari, are mere 4 days in a year enough? Let us at least get some information on how many Lok Adalats have been conducted and what is a resolution. Let us at least get some information before we make a judgment. Okay? Relax, just calm down. Now, this Lok Adalat shall consist of a chairman and two members, members having adequate experience in public utility service. So, as I explained here, in this case, this lady and this gentleman here, these two are experts in this field, maybe banking, right? So, they are there. Now, Lok Adalats are places where you can file civil cases can be resolved, or even compoundable criminal cases can be resolved. Compoundable offenses are petty offenses where out of court settlement is allowed. That is called a compoundable criminal case. Are we clear? For example, if you kill somebody, that is not a compoundable case. That's a very heinous offense. It's non-compoundable in nature. You cannot simply say sorry, matter over. But imagine a situation where in your college, two groups are fighting. Okay? Two groups are fighting, and the police comes. Now, the police will never register a complaint against the group. Why? You two are randomly fighting to impress a third person who's standing there who doesn't even know you are fighting to for him or her. And what happens? The police will slap both the leaders and say, come on, shake hands, get lost. Case over. If you are pickpocketing, say you take somebody's purse, steal it. The police can simply give you two nice ones and you have to say, okay, purse given back, case over. The police will not file a case against you. These are small offenses where out of court settlement is allowed. So Lok Adalat can also deal with criminal cases, but petty, small criminal cases, not murders and all. No. It is also available in the pre and the post litigative stage. Litigative stage meaning court, in the courts. As I said, you can file a case in the court and then go for compromise in Lok Adalat, or you can go for a compromise before and then go and file a case in the court if the compromise does not work. So either way, the court's door is always open. It is your choice whether you want to go to Lok Adalat or not. So it is possible that you have a case filed in the court. You have a case filed in the court and still you want to save your time and energy and money and go to a Lok Adalat. Clear? That's also possible. Or you can firstly go to Lok Adalat, and if things don't work there, then you go to court. Simple, right? Now, one very, very important point. This is a compromise. The bank has offered you a compromise. In our example, I said that the bank has given you 20% discount. If you agree, please come on that particular date and then sign the order, compromise. Done. If you don't accept for the compromise, then the bank already has an option to go to the court. The bank will say, okay, no problem. I tried my best. I'll go to court. You say, okay, go to court. Are we clear? You're not bound to accept the offer. Are we clear? For example, if once you clear the examination, some of you, of course, once you clear the examination, there'll be a lot of people who will come to you and will approach you. Oh, amazing, you're such a nice fellow. I always loved you secretly. Please accept my love. Let's say somebody comes to you and expresses their emotions, says, I love you. Now, what are the options that you have in front of you? Tell me. What are the options that you have? two options: accept or reject, ignore, right? You cannot ask the person this question, no, no, why have you come? Why your friend has not come? Are you clear? You either say yes or ignore it, reject. Are you clear? Yes or no? No, okay, feel the expression and decide, but you can only either accept or reject. You cannot question them. Right? Why your friend has not come? Why have you come? Clear? Similarly, if the bank has offered you 20% compromise, you can't go to High Court. High Court, bank is giving me 20% compromise. Why not 30%? Sorry, it's a compromise. Accept it or ignore it. You cannot question it. Are we clear? So whatever award is given by the Lok Adat is binding and cannot be challenged. Are we clear? The award given by Lok Adat cannot be challenged anywhere. Do you understand? It cannot be challenged anywhere. And do you understand the logic now? Why it can't be challenged? Because it's a compromise. Either you accept it or you ignore it. No problem. Clear? I hope you will not be asking this question after 10 days that, sir, High Court possible? Supreme Court possible? It is not possible. Apply this. Top story has to be applied here. That it is not possible to challenge it. Simple. Done and dusted. Now, one more thing. And Siva, I think my capacity to explain things is just exhausted when it comes to you. I'm not sure what you understand, sir. What is the concern here? I'm not really sure. You only have 7, 8 letters in your keyboard. No, do not understand. See, whatever award is given is binding on parties to follow. Now, some of you can say, sir, what if I don't follow? Nothing happens. Simple. It was a compromise. Nothing happens. What will happen? If you don't give the money, the bank always has the court to go to. Court's doors are always open. That is why we say the award is binding on the parties. Both parties have to follow it. But what happens if you don't follow it? If you don't follow, the bank can go to court. Are we clear? If you follow, the bank's problem is solved. Clear now? Is there still some problem now? No, they can't punish. How can Lok Adat punish? I am using from the very word go, I am saying compromise. How can a court which is meant for compromise punish you? They cannot punish you, right? And in case you want to go to Lok Adalat, Anuj, award is binding on both parties. Then how bank can go to court? The bank can go to court if you do not fulfill your obligation. Simple. The bank can go to court if you do not fulfill the obligation. Are we clear? Pooja, that is why we say the award is binding. That's how we write. It's a legal sentence. Awards are binding, meaning this award is final and fixed. That is binding. You are bound to follow it. If not, then the bank can go to court. That's the meaning of it. I'm explaining this. Manam, were you attending the class constantly or were you missing? I just explained pre and post litigative state, sir. How will you ever move on if I have to keep on repeating for just handful of you everything? Pre and post litigative stage means the case can be filed in the court at any point of time, right? And also in the Lok Adalat at any point of time. Court and Lok Adalat are two independent bodies. Are we clear? Lok Adalat is a separate body. Courts are separate. Are we clear? I can go to both places at the same time. I will say I am going to try my luck in both places. In the court, I have the advantage. I'm a banker. I have the advantage. In the court, I can get a full judgment. My full 1 lakh will be returned back if the court punishes you. But in the Lok Adalat, I'm going for a compromise. I'm losing some money. But the point is, I know very well that in the court, my number will come, say, after 10 years. I can't wait for so long. I leave it. So I can go before filing case in Lok Adalat to the court, afterwards also. Same thing. If I have filed a case, I can go to Lok Adalat. If I have not filed a case, I can still go to Lok Adalat. Done. Beyond this, watch the video and understand it. Okay? If that's also difficult, mug up those facts. Simple. Clear? Because beyond this, I don't think gods can come and make you understand. Human beings cannot. Now, up to what amount can we go to a Lok Adalat for compromise? Vijay Mallya, fraudster, Vijay Mallya was a businessman who has taken some loan and has become a defaulter, right? If he is a defaulter, he has defaulted on loans running in thousands of crores. Can we go for a Lok Adalat? No. The limitation is 1 crore only. So any amount under 1 crore, you can go and get a compromise. This is as per NALSA website. So if in your book, Lakshmikant, etc., this amount is written as 10 lakhs, that is not my problem. Okay? That may be old information. Why the books are not updating themselves? Please don't tell me, sir, book says something else. This is the latest information. Simple. Are we clear? Now, somebody was saying, what is the contribution of Lok Adalat, etc. Just to tell you, 2021, in the Lok Adalat, 1.27 crore cases were disposed. $1.27 crores. In 2022, 4.19 crore cases were disposed. Disposed meaning solved. Don't think, sir, thrown. Dispose means thrown. No. Solved. In 2023, I don't have data now because the fourth Lok Adalat is still to be conducted. But just to give you the data of September 2023, this one Lok Adalat only, in September, that was held recently, you'll be surprised to know that 1.7 crore cases were solved. 1.7 crore cases were disposed in just one Lok Adalat. Are you clear? And the total amount value in terms of money was around 1,224 crores. Imagine if all these cases had gone to the lower courts. The pendency would be looking at would be 10-15 crores. Judges would have to commit suicide only. They cannot solve all these cases. So Lok Adalats are of great help. Why do we have limited Lok Adalats? Is because we want to firstly spread information, right? So when it comes to any such issue where how to approach, you can't approach. You can't approach. Okay? Lakshmi, it's September of 2023, not 23rd of September. Anyway, so as I said, you can't go and approach on your own. Somebody else has to. So let's say the bank is collecting information on all the defaulters. It will send you a letter and will inform you. If you are willing, go to Lok Adalat. You have lot of traffic challans pending against your name. You are not paying that amount. The police thinks, let's do one thing. All those people who are not paying their traffic challan, let's ask for a compromise. So the police will inform you that you have not paid a challan. This is a compromise. Do you want to have a compromise? Come on that date. Are we clear? This is what is done. It's a temporary court which is set up for one day. where people with respect to various cases will come, get a compromise all across the country, and will get their cases resolved. It's not one court or two courts or 10 courts. Are we clear? Everybody, you come on that day because you are willing for a compromise, stamp, sign, gone. Go home, enjoy. Case closed. Are we clear now? Or still there is some problem? Okay, solve this question now. Anuj, we don't have a single Lokalat in the country. It is set up for one day only, and it's dissolved on that very day. Done. Okay? VK Kush, that's not possible. No puja. That's not possible. Okay. Uh, we just saw all these things. How can you make a mistake here? Lok adalats have the jurisdiction to settle the matters at pre-litigative stage and not those matters pending before any court. I just said that they can be used for pre and post litigative stage, meaning they can settle matters at any point of time. Wrong. Lok adalats can deal with matters which are civil and not criminal. I mentioned here compoundable criminal cases also. Wrong. Every Lok Adalat consists of either serving or retired judicial officers only and not any other person. That is also wrong. Two experts in the field of public utility are also a part of Lok Adalats. None of the statements given above is correct. Okay, now Gram Nyayalay Act 2008. What is Gram Nyayalay? Gram is village, Nyayalay is a court. Okay, so it is a village court. Now, village court does not mean a court in every village, but yes, something of that sort. So, what is this Gram Nyayalay? If you cannot go to the court, don't worry, court will come to you. Now, providing access to justice to the citizens at their doorsteps. Please don't think that the court will, the judge will come to your house. He will knock every door. Justice, justice, anyone? Justice, you want justice? No, it is not like, Nana Patekar selling onions and potatoes, right? So don't have this feeling. To ensure that justice is not denied due to social, economic, or other disabilities. So this Gram with this picture from Petara Yudu. Petara Yudu? Oh, I thought the Tamil version is called Natamai. But anyway, Petara Yudu is the Telugu version of it, right? The original movie. Or Natamai is the original. I'm not sure which is the original one. There is a Tamil version, there is a Telugu version, and there is a Hindi version called Bulandi. Acha, Natamai is the original version. Okay. Don't fight, it's okay. Anyway, it's not a great movie. It's an average movie only, right? Let's not fight. हाँ भाई तेलुगु तमिल relax. Don't fight. Yes, yes. Okay, so now coming to the provisions. Number one, This Gram Nyayalaya is not there in every gram. It's there in every block, firstly. To be established at intermediate panchayat level. Sometimes it can also be done or for a group of villages. That's also possible. But it is normally established at a block level. Block level. Okay. Now, currently, it is operational. See, as far as this law is concerned, it came into force on the 2nd of October, Gandhiji's birthday, 2009. Okay. And it is currently operational in 10 states, though 15 states have issued notices, but 10 states actually have a functional Gram Nyayalaya. Okay. Now, uh, as of now, we have 370 functioning Gram Nyayalaya. I hope I can write this GN, Gram Nyayalaya. Nobody should be confused. Now, 370 functioning Gram Nyayalayas with the highest number of operational Gram Nyayalayas in Madhya Pradesh, then UP, then Rajasthan. Maximum in MP. What about funding? Rupees 18 lakh per Gram Nyayalaya, one time by center. And then the states will manage it on their own. One more thing. Gram Nyayalaya is not there in the northeastern parts of the country. So these courts are not there in Arunachal, Nagaland, Sikkim, and Schedule 6 areas. So this law, Gram Nyayalaya Act, is not applicable to states like Sikkim, Arunachal, Nagaland, and Schedule 6 areas. Okay. So that's there. Now, this court has only one judge. That person is called Nyayadhikari. Basically, Nyayadhikari is a judicial magistrate, first class. If you remember, the subordinate court hierarchy on the session side at the lowest level, just above the magistrate cum civil judge, in the district judges category, the lowest judge at the session side was called judicial magistrate first class, right? So basically, that's what an Nyayadhikari normally is, appointed by the state government in consultation with the High Court. Now, this person draws the same salary and has the same power as a first class magistrate working under the High Courts. Judicial magistrate. I am constantly in the beginning also somebody asked me, sir, DM versus DC or DM versus JM. Sir, district magistrate is an administrative officer, right? He's an executive. Judicial magistrate is a judge. There is no comparison only. Don't get fooled and confused by the word magistrate, because till 1973 district magistrate, but after new CRPC they have no such power to punish anybody. Are you clear? Okay. Now, what is the logic of this, or how is it conducted? So let's say you are in a village and you have some issue or concern. What kind of concern? Let's say you were hired by somebody to perform some task, and the person did not pay you the wages which were required to be paid, or the person did pay you the wages but not as per the laws. You were paid wages lesser than the minimum wages that are there. Or say something like your neighbor's cattle have entered your field and have completely destroyed your crops. So these kind of laws do exist in the country. If such things have happened, then you can tell the gram panchayat. Gram panchayat will collect the information of all these cases and will report to the block. Block tells the district collector. DC informs the high court. High court gets information. It finds out that, oh, in this particular area there are too many pending cases. So it will send one. Come on, you JM first class, come here. Go to that area. Sit for 2-3 months there, and then resolve the cases. So in all the villages in that particular block, intermediate panchayat level, in the your gram panchayat office, a notice is stuck that on the 26th of October, for the next 15 days or 2 months, whatever, a judge will come and sit. Any and every complaint that you have, you can bring, and those complaints will be resolved. You can go get your complaints resolved. So these Nyadhikaris have both criminal and civil powers, meaning both criminal and civil cases can be filed, but small only, because there is a limit. What's the limit? In a civil case, fine cannot exceed 20,000, right? In a criminal case, punishment cannot exceed 2 years. This means you can't murder somebody and go to Gram Nyalaya. For smaller cases only, beating somebody, etc., stealing, etc. Clear? Smaller cases only. Just to give you an estimate, 1.6 to 1.7 lakh cases are filed per month, and around 16 to 17,000 cases filed per month. Clear? Now, one more thing. The idea is to dispose of cases within 6 months. They will dispose of case in 6 months. So they hold a mobile court of sorts, periodically visit villages, conduct trials and proceedings. Simple, right? Now, Gram Nyayalaya does not follow rules, regulations like Indian Evidence Act and all. No drama, no lawyer, nothing is required. If you want to hire a lawyer, hire a lawyer. It is not required. What is done? They simply follow principles of natural justice. I hope you remember what are the principles of natural justice. Do you remember it? It was explained very clearly under the topic Article 136, Special Leave Petition. 3 elements. Number 1, no one shall be judged in their own case. Number 2, hear both the sides. And number 3, give reasons for judgment. Simple. That's all that is followed. Nothing else is followed. You want to bring a lawyer? Bring a lawyer. You don't want, you argue your own case. No problem. In fact, even before your case is filed in the Gram Nyayalaya, the Gram Nyayalaya looks into all these complaints. If there are some very basic and petty issues, then the Gram Nyayalaya will enable attempts to effect settlement. If in case there's a possibility of settlement of disputes, the Gram Nyayalaya can appoint some local influential people, maybe some sarpanch there, some village headman there, some old people there who are reputed people there, some social activists there. They can be hired as conciliator, mediator, and they can resolve the disputes there only. And whatever remains can go to Gram Nyayalaya. Are we clear on this now? Gram Nyayalaya. Couple of things. It's not free. Okay? Money is required. Otherwise, everybody would go to Gram Nyayalaya only. Money is required. How much money? Don't worry. It's not a huge amount of money. It's just 100 rupees. So to go to Gram Nyayalaya, fees is mandatory. Rupees 100. Okay, point one. Secondly, can you appeal? Yes, appeal is allowed in the district court. Just once, that's it, done. You can't go to High Court and Supreme Court, district court only. And also appeal, what's the condition? Condition for appeal would be if fine is more than 1,000 rupees, only then can you appeal. If you have been given fine, imposed a fine of 500, you have to pay the fine. No appeal. Or jail sentence. Then you can appeal. Otherwise, no appeal. Sorry, punishment is final. Clear? This is what is called a Gram Nyayalaya, trying to resolve cases at the grassroots level only. Basic cases like laws of what kind of laws do we have? We have a very old law called Cattle Trespass Act 1871, or Payment of Wages Act 1936, or Minimum Wages Act 1948. These kind of laws are enforced by the Gram Nyayalaya, which is headed by a Nyayadhikari, who is a JM first class appointed by the government with respect to consultation with the High Court. Clear? Okay. Solve this question. Asked in 2016. So, yeah, sir, then what kind of punishment can they give? Sir, it is mentioned on the slide. They can give a punishment of up to 20,000 rupees of fine or up to 2 years of jail. It was there on the slide. Okay. Great. As per the Act, Gram Nyayalayas can hear only civil cases is wrong. It can also hear criminal cases. Right? So, sorry, not this being wrong. This only is wrong. Criminal also. The Act allows local social activists as mediators or reconciliators is correct. B2 only is correct. Done. Now, let's look at a very, very interesting topic, and that topic is judicial activism. Right? A topic very near and dear to everybody's heart because it's a very, very important topic. Satyapal sir, is it necessary to use mediator? No, sir. It's an option. If you insist on filing case, don't use a mediator. That's always an option. Judicial activism. What is the meaning of judicial activism? Firstly, let me tell you the source. What's the source of judicial activism? Article 142, Article 32, Article 226. These are all sources because the courts have the right, or courts have the duty to protect your rights. Also, the Supreme Court can give any kind of decree or order to ensure complete justice. Now, please understand very carefully. I'll draw a diagram to help you understand what's the concept of this activism, judicial activism. Think of this. We have three organs. So we have the legislature, judiciary, executive, right? Clear so far? Every organ has been given an area to perform. For example, legislature's task is to make laws, executive's task is to bring out policy, social welfare, making or implementing laws, etc. And judiciary's task is to interpret laws. Clear? Every organ has been given certain functions. Clear? So far, everybody okay? No problem? Okay, great. All okay. Now, second thing, let us assume that the legislature performs its tasks. Very nice, you should. This is your area to perform. This is your area to perform the task. You are performing your task. No problem at all. Keep performing very well, very nice. But we are witnessing that there is some area where they should be performing their task, but they are not. Can you observe this? That they are not performing tasks which fall in their domain for whatever reason. For whatever reason, right? Same thing can go for executive also. They are performing their tasks very nice, very good, making policies, etc. But we are finding that for certain areas, they are either deliberately or because of whatever reason, they are ignoring those areas which fall under them to perform. Clear? Now, if the legislature does not perform tasks which are allocated to it, if the executive does not perform tasks which are allocated to it, then what do we do? Should we sit and cry? Or should the third organ take matters in its own hands? See, judiciary's task is very simple. Judiciary's task is to perform in this area. This is the area of judiciary to perform. Simple. But the problem is that judiciary is witnessing that these organs are not performing the tasks which have been given to them either in the constitution or in the parliamentary setup. So somebody has to perform those tasks or at least instruct them to perform those tasks. Then what happens? This judiciary will now be forced into crossing its boundary and entering the domain where they have to give the executive, give the legislature some order or maybe perform tasks on behalf of them. Why? Because they are not doing it. It is just like if you have eaten food and you have not taken the plate to the sink, somebody has to do it. It's not your mom's responsibility, but since you are not doing, she has to do it, right? Same thing. Now, some of you may say that, sir, but judiciary is crossing its boundary. It's wrong. Yes, it's wrong. Judiciary is crossing the boundary which was democratically designated to it. But the problem is that because of the failure of the other two organs, I have to cross the boundary. Are you able to understand it? This is what is called activism. This, what the judiciary does, is activism. Are we clear? Everyone, tell me, is the diagram understood by all? Okay. But I'll give you examples. Don't worry. I'll give you examples, plenty of examples on what and how these things are done. But a small point. Sometimes judiciary may cross its limits and will also try to interfere in those areas where the legislature, where the executive are performing their tasks. Right? Imagine now that you are doing your work properly, but somebody comes and says, no, no, not like this, like that, like I tell you to. Simple example. I'll give this example later on also. To stand up for the national anthem as a mark of respect, of course, every citizen should do it. But first, it should come naturally. Number two, we are doing it anyway. We have been trained like this in the school days that it's very natural that if some national anthem plays somewhere, we automatically cannot keep sitting. And if you're doing it, you are very, very conscious of the thing you're doing, right? It's very natural. Now, and suppose if you have to give an order to stand up for the anthem, these things should come from the parliament or should come from the government. That to respect the anthem, we have to stand up. Home Ministry gives an order. Understood? But in 2016, the Supreme Court gave the order that it's mandatory for people to stand up for the anthem. Why? Now, who are you to tell us? Is this your task? No. This order should come from the government. Secondly, Supreme Court also said it's mandatory for every theatre to play the anthem. Later on, it was revised. It was made optional. But theatre have to play anthem and you to stand up for the anthem. Now, one very important point is that now you are trying to interfere in the domain of legislature and the executive and telling them what to do and how to do. This is wrong, right? So what we are referring to is a situation where the judiciary is now crossing its boundaries and entering a domain where they are actually trying to perform tasks or giving instructions which do what? Which enter the domain of the legislature and executive. This is what is the reference to overreach. You can also call it adventurism. You can also call it populism. This justified, this not justified. Did we understand the difference between activism and overreach through this diagram? I'll give a lot of examples for you to see how it is activism and how suddenly it becomes overreach. But as of now, are we all clear? Okay, great. Let us see a definition of sorts. Democracy's non-democratic alternative. When the democratic institutions fail, legislature has failed to perform its tasks. Executive has failed to perform its tasks. Democratic institutions have failed. Non-democratic alternative. Judiciary is now interfering. We know it is wrong. It is undemocratic. It is wrong because judiciary, your limit was this only. But because other organs have failed, this undemocratic alternative is what is called activism. Clear? For example, if something goes wrong, the right thing is to approach the police station and file a complaint with the constable there, and then the matter goes to court. What if the constable refuses to take up your complaint, you go to the SHO, the Thana in charge, the station house officer. If he also acts over smart, you go to the city SP. If they act over smart, you go to the, say, DGP. Now, if the institutions have failed to live up to the expectations, what's left for us? Come on the road, protest. Nobody wants to protest. It is because others have failed to perform their duties that you are forcing a citizen to leave his job and come on street and protest. Had you performed the tasks properly, you would not have protested. That is activism. Same thing here. When judiciary does it, judicial activism. Are we clear? And a very important element to understand is that judiciary keeps on saying, why are we doing this activism? The idea is that courts can never be silent spectators. I'll mention this point here for you to write also. Courts can't be silent spectators when rights of people are being infringed upon by legislative or even executive action. Are you clear? Courts have a duty to interfere. And that is why we say that the court says that courts can seek constitutional justification for actions for executive or legislative action. On what grounds? That they should be reasonable, they should be non-arbitrary, they can't be random actions, and they should not violate rights of people. Violate the rights of people. Clear? So this is what is the idea behind judicial activism. Tomorrow, I'll give you reasons for activism. We'll see what is a PIL, some examples of PILs. We'll see the current examples of how the courts have shown activism and then the positive implications. And then I'll give you plenty of examples with respect to what has been the concern so far as the issue overreach is concerned. Once we are done, we'll move on to looking at the tribunals also. Okay. So that's it for today. Let's end our discussion here only. And we'll move on and discuss activism further tomorrow. Okay. Leaderboard for the day. Today we had only those previous year questions. So a lot of you have already taken a batch and all, you know the answers, right? So I don't really rely on this today's leaderboard. My questions, what you solve, would be the real test of leaderboard, right? So, toppers for the day. No claim over chocolates. Extremely sorry. Done. Okay. Questions, if any, please. Questions. That is going to be all for today, guys. Jai Hind. In case you want to leave, you can leave. I'll just I'll mention a task here to perform. PPTs, editorials, monthly magazine, Yojna Kurukshetra, and political theory must go on. Pihu, review is checking the constitutional validity of an executive or legislative action, whereas activism is looking into not just the validity but also looking into those areas specifically where there has been inaction. That is why this diagram is important. It focuses on the inaction part, on the part of legislature and executive. More questions? Okay. There is no need to make notes from monthly magazine. It in itself is a notes. Just keep that with you and mug up regularly. Basu, what is conduct? Conduct means behavior. Sir, I cannot in the parliament discuss on the judge's behavior, on what he said in a judgment negatively. That's called discussing the conduct of a judge, the behavior of a judge, right? You cannot discuss the behavior of a sitting judge. Whether you like his judgment or not, that can't be discussed in the parliament. That, oh, this judge, I think he has given a judgment because he is in favor of BJP. You can't make all these statements. No, Rajan, that's not a reason of pendency. Mayank Wadhwani, of course that can happen, right? But why would this happen with a proper institution? Who would take the risk? Madam, there is no perfect strategy plan. Firstly, why are you not reading standard books? Then what are you doing then? Read standard books first. Muskan, there are hundreds of reasons. People have not turned up for the on the day they were called. Police has no evidence, proper evidence. The lawyers want a different date, etc. By Megha, your name is not in the list because only top 20 fastest answers are put. If you had answered very fast, your name would be in the list. Simple. No A.S. Hussain. Ruchita, it's a discretionary power of the governor. Venu, it is not required to remember verbatim. Manam, not required. Underline important points, write in your notes separately. If take MLA, K Mahesh, it is not required actually. No Shivam, that's not possible. No, no, Nitin, it's payment basis. Nothing is free. Kancharla, it is given by state government, not charge and all, just simple salary. Arshat, that is something the courts have to decide, right? What can we do? We'll discuss that. How courts also show inaction tomorrow. More on this tomorrow. No, Yashi, Lokadats in every district may not be the case, right? It will depend. Mayank Wadhwani, those people are not given bail because of certain reasons. Because there is strong evidence against them. They have not furnished the bail bond. There's a threat that they will abscond if they are let out, or if they are let out, they may tamper with the evidence, they may harass the witness, etc. That is why. Yes, yes, guys, feel free to leave in case you have no doubts. No, madam, not at all required. Just mug up this information. Nothing else. Okay, Pooja, great. Okay, guys, that's it for today. Let's end our discussion here only. Tomorrow we'll have more fun, more interesting things. No, Lakshya, I'm not really sure what your concern is. So, what is this case? What is the story? You're just quoting a small statement, so I cannot make out what exactly is the point you're trying to mention actually. So, clearly, it is not really important. Anyway, that is all for today, guys. Let's meet tomorrow. Till then, that's all for this class. Jai Hind.